All right, now this is an obscure document and you may never use it, but we still want the video. It's called Michigan Realtors Exempt from Michigan Sellers Disclosure Act. So this describes the scenarios in which the seller is not responsible to fill out seller's disclosures. I am going to read these verbatim just so you know the specific circumstances. So address is here, listing dates here. The above listing is exempt from the Michigan Seller Disclosure Act under the following exemption. Number 1, transfers pursuant to court order, including but not limited to transfers ordered by a probate court in administration of an estate, transfers pursuant to a writ of execution, transfers by any foreclosure sale, transfers by a trustee in a bankruptcy, transfers by eminent domain, and transfers resulting from a decree for specific performance. You might say, why? In all of these situations, the people that are actually selling the property would have no knowledge as to the condition of the property. Number 2, transfers to a mortgage by a mortgagor or successor in interest who is in default, or transfer to a beneficiary of a deed of trust by a trustor or successor in interest who is in default. This involves essentially a foreclosure. Again, whoever has foreclosed on the previous owner, they're going to have no knowledge as to the condition of the property. Number 3, transfers by a sale under a power of sale, or any foreclosure sale under a decree of foreclosure after default in an obligation secured by a mortgage or a deed of trust, or secured by any other instrument containing a power of sale, or transfers by a mortgagee or a beneficiary under a deed of trust who has acquired the real property at a sale conducted pursuant to a power of sale under a mortgage or deed of trust, or sale pursuant to decree of foreclosure and has acquired real property by a deed in lieu of foreclosure. So this again involves foreclosure where somebody has acquired the property, and again, they're selling it, but they would have no knowledge of the condition of the property. They're also exempt from disclosure. The next one, transfers by a non-occupant fiduciary in the course of administration of a decedent's estate, guardianship, conservatorship, or trust. This would be like an estate type situation. Maybe your mom owned a home, she passed away, you're selling it as part of the estate. You've never lived in the property. Again, you'd have no knowledge of the condition of the property, so you're exempt from filling out the seller's disclosure. The next one, transfers from one co-tenant or one or more other co-tenants. This is would be extremely unique. You'll never deal with this, but that's all I can say there. Next, transfer made to a spouse, parent, grandparent, child, or grandchild. So if it's a non-arm's length transaction to a close family member, the disclosure is not required. Transfers between spouses resulting from a judgment of divorce or a judgment of separation maintenance, or from a property settlement agreement incidental to such judgment. So you're getting divorced, you're selling your interest of a property to your exes, you don't have to fill out a seller's disclosure. It's already inferred that they would know the condition of the property. Next one, transfers or exchanges to or from any governmental entity. If you're selling to the government or you're buying from the government, there's no disclosure. Next, transfers made by a person licensed under Article 24 of Act Number 299 of the Public Acts of 1980, being sections 339.2401 to 339.2412 of the Michigan compiled laws of newly constructed residential property that has not been inhabited. So like this is like you've had a new home built, the builder's not filling out a seller's disclosure. That's all that means. And then you sign this. So pretty obscure document. You're not going to need it very often, but if you're selling for an estate, you will need it. That's it.